Howdy, I'm CyberX with Outlandishly Crafted. And today we're going to be talking about UDIO changing their terms of service and adding a class action waiver. That sounds like something a big, huge corporation would do, like UMG. It doesn't sound like something a trusted small business would do, like UDIO. But it turns out it is now because UMG seems to be sending their lawyers in. So I thought we would read this together and we would talk about this nice little 9.6 line. Someone had sent me a comment in a YouTube video saying, hey, you have to opt out in the next 30 days or you won't be able to sue them. Just automatically. It's going to kick in, and the terms of service, whether you know it or not, it's your responsibility to go check them. They didn't send them to us in an email and tell us, even though they have our emails, which I believe in the EU is a violation. You can't just change the website. You have to actually send us an email notifying us of this. That's why Microsoft and Mojang are currently being sued. But I've gotten no emails about it. Maybe I just didn't check the right box. Maybe it's in a spam filter somewhere, but I haven't seen one. There weren't any announcements on the main page. It's just buried here in the terms of service. Now, to give them credit, because they know that this would come up in a court battle, they did put a date. That's more than Microsoft ever did. And they did note this big note at the beginning here of this. So they're trying to cover their ass as best they can, but so let's jump down to section 9, and I don't want to read all of this to you, so I'm going to have
arbitration and class action waiver.
Do it.
9.1 Please read this section carefully. It may significantly affect your legal rights, including your right to file a lawsuit in court and to have a jury hear your claims. It contains procedures for mandatory binding arbitration and a class action waiver. 9.2 Informal process. First, you and the company agree that in the event of any dispute, either party will first contact the other party and make a good faith sustained effort to resolve the dispute before resorting to more formal means of resolution, including without limitation, any court action, after first allowing the receiving party 30 days in which to respond. Both you and the company agree that this dispute resolution procedure is a condition precedent which must be satisfied before initiating any arbitration against the other party. 9.3 Arbitration agreement and class action waiver. After the informal dispute resolution process, any remaining dispute, controversy, or claim, collectively, claim, relating in any way to the company's services and/or products, including the services and any output, and any use or access or lack of access thereto, will be resolved by arbitration, including threshold questions of arbitrability of the claim. You and the company agree that any claim will be settled by final and binding arbitration, using the English language, administered by JAMS under its comprehensive arbitration rules and procedures, the JAMS rules. Then in effect, those rules are deemed to be incorporated by reference into the section, and as of the date of these terms. Because your contract with the company, these terms, and this arbitration agreement concern interstate commerce, the Federal Arbitration Act, FAA, governs the arbitrability of all disputes. However, the arbitrator will apply applicable substantive law consistent with the FAA and the applicable statute of limitations or condition precedent to suit. Arbitration will be handled by a sole arbitrator in accordance with the JAMS rules. Judgment on the arbitration award may be entered in any court that has jurisdiction. Any arbitration under these terms will take place on an individual basis. Class arbitrations and class actions are not permitted. You understand that by agreeing to these terms, you and the company are each waiving the right to trial by jury or to participate.
I just wanted to pause because I think it should be illegal for any company to remove your rights and to say that you can't class action sue them with a document hidden somewhere. Even if they pop this up on the screen and it scrolls through and you agree to it, they shouldn't be able to just say, you can't sue us. You can't class action sue us. Where in any like constitution or any government oversight would you allow someone to say, I'm going to enter an agreement with you, but you can't sue me? Well, why not just say you can't do anything? You can't talk to me. You can't. We're going to be in a partnership, but I'm not going to provide any support. I'm never going to talk to you. We're not going to have any interaction. So we're not really in a partnership. It's really, I'm forcing this on you and you're going to bend over and take it. This isn't a 50-50 fair consumer partnership between two people in a equal playing field. This is them covering up because they know they're violating the consumer's rights, and they're doing everything possible, even saying lack of access to data. They're doing everything possible to check off every box and say, we know we're violating your rights. We know we're being an abusive entity. We know we're not being a fair, honest partner. We're being fraudulent. We're misrepresenting. And we are just going to be allowed to do it because we wrote it down. Huh? Can I go put on a side of my house that I write down that if you walk into my property and then you slip and fall because of my negligence, I'm not liable? Is that how the law works?
In a class action or class arbitration. 9.4 Exceptions. Notwithstanding the foregoing, you and the company agree that the following types of disputes will be resolved in a court of proper jurisdiction. Disputes or claims within the jurisdiction of a small claims court consistent with the jurisdictional and dollar limits that may apply, as long as it is brought and maintained as an individual dispute and not as a class, representative, or consolidated action or proceeding. Disputes or claims where the sole form of relief sought is injunctive relief, including public injunctive relief, or intellectual property disputes. 9.5 Costs of arbitration. Payment of all filing, administration, and arbitrator costs and expenses will be governed by the JAMS rules, except that if you demonstrate that any such costs and expenses owed by you under those rules would be prohibitively more expensive than a court proceeding, the company will pay the amount of any such costs and expenses that the arbitrator determines are necessary to prevent the arbitration from being prohibitively more expensive than a court proceeding, subject to possible reimbursement, as set forth below. Fees and costs may be awarded as provided pursuant to applicable law. If the arbitrator finds that either the substance of your claim or the relief sought in the demand is frivolous or brought for an improper purpose, as measured by the standards set forth in Federal Rule of Civil Procedure 11b, then the payment of all fees will be governed by the JAMS rules. In that case, you agree to reimburse the company for all monies previously disbursed by it that are otherwise your obligation to pay under the applicable rules. If you prevail in the arbitration and are awarded an amount that is less than the last written settlement amount offered by the company before the arbitrator was appointed, the company will pay you the amount it offered in settlement. The arbitrator may make rulings and resolve disputes as to the payment and reimbursement of fees or expenses at any time during the proceeding and upon request from either party made within 14 days of the arbitrator's ruling on the merits. 9.6 Opt-out. You have the right to opt out and not be bound by the arbitration provisions set forth in these terms by sending written notice of your decision to opt out to info@udio.com. The notice must be sent to the company within 30 days of your first registering to use the services or agreeing to these terms, otherwise you shall be bound to arbitrate disputes on a non-class basis in accordance with these terms. If you opt out of only the arbitration provisions, and not also the class action waiver, the class action waiver still applies. You may not opt out of only the class action waiver and not also the arbitration provisions. If you opt out of these arbitration provisions, the company also will not be bound by them. 9.7 Waiver of right to bring class action and representative claims. To the fullest extent permitted by applicable law, you and the company each agree that any proceeding to resolve any dispute, claim, or controversy will be brought and conducted only in the respective party's individual capacity and not as part of any class, or purported class, consolidated, multiple plaintiff, or representative action or proceeding, class action. You and the company agree to waive the right to participate as a plaintiff or class member in any class action. You and the company expressly waive any ability to maintain a class action in any forum. If the dispute is subject to arbitration, the arbitrator will not have the authority to combine or aggregate claims, conduct a class action, or make an award to any person or entity not a party to the arbitration. Further, you and the company agree that the arbitrator may not consolidate proceedings for more than one person's claims, and it may not otherwise preside over any form of a class action. For the avoidance of doubt, however, you can seek public injunctive relief to the extent authorized by law and consistent with the exceptions clause above. If this class action waiver is limited, voided, or found unenforceable, then, unless the parties mutually agree otherwise, the parties' agreement to arbitrate shall be null and void with respect to such proceeding so long as the proceeding is permitted to proceed as a class action. If a court decides that the limitations of this paragraph are deemed invalid or unenforceable, any putative class, private attorney general, or consolidated or representative action must be brought in a court of proper jurisdiction and not in arbitration. 10 Additional provisions.
So, it sounds like to me that because I've been using the service for more than 30 days, I can't opt out anymore, and I no longer have any rights to do pretty much anything except take them to small claims court individually under arbitration first. It's a joke. This should be illegal. $10 says that most of this wouldn't hold up in court if you actually showed up in court and you actually challenged all of these lines. But I'm not a lawyer, right? This isn't legal advice. How can this not be consumer abuse if you lose all your rights just by using the service? That why why have any rights then? What rights are not removable by words? Rights are God-given. The Constitution is very clear about who gives our rights. You can't take away my rights by some words on a website somewhere that you sneak into a terms of service. And if that's how the system works, it needs to be fixed and changed. If you abuse someone, you should be held accountable for it. You know? And people are going to say, well, but UMG, UDIO abused UMG. Maybe so. I think they should go to court, and a judge and a jury should figure out what's right or wrong within the copyright system and what was violated and what wasn't violated, and they should figure it out and make a decision instead of playing this middle ground and putting the consumers in the middle. And then our only option is to be bent over, sue the company one at a time, or if you're new within 30 days, opt out of this and class action sue them. File a Justice Department complaint for antitrust, this is clearly antitrust from the side that I can see, from UMG's side. UMG has a competing product. It failed, and then it went and took down everybody else that it could and absorbed their products into it and removed options from the market from the consumers to control the market, and it used its weight and power as a monopoly and a controller of most of the market other than Sony to do it. If Google's doing it and Microsoft's doing it with all of their stuff, then how is UMG not doing it when they control the artist? Now they're going to control the production method as well. So if you're new to the service, you should opt out, and remember, you have to opt out of both the arbitration and the class action. It says in there if you only state one, the other will still apply. In essence, you have to have a lawyer, go pay a lawyer, $2,500 for the hour to read through this, to then give you a document that you could send him to opt out. They've made it hard enough that a normal user can't process and do this and know all of this, and they expect us to get a lawyer to know what our rights are, what we can do, or they'll say, well, just don't use the service. So my choices are be abused or don't use your service. That doesn't sound like consumer protections. It doesn't sound like a fair playing field. It doesn't sound like my rights are being protected. So once again, if you think that this is invalid and abusive consumer practices, then please contact the Department of Justice.